Welcome, everybody. My name is Joe Garcia, and I am the program director for the Fair Housing Center of Nebraska and Iowa. Um, we've got a lot of folks joining us as I'm talking. We're excited for this presentation, for doing this presentation. Um, Whenever we get the opportunity to talk about fair housing, uh, we jump at that opportunity, and I'm really excited for a couple of reasons. Like I said, whenever we get that opportunity, we jump at it to talk about fair housing. I'm also excited because I'm bringing my staff in on this to talk and to have them share their expertise with you folks. Um, I've got a great staff, and it also helps putting a name, a face with the names that you hear. Uh, this training opportunity came about a couple of months ago. A friend from Scottsbluff, Nebraska, Kendra Dean with Cirrus House, reached out to me and asked if we would be if we do trainings, if we would be willing to do a training for her and her staff. And I said absolutely. We could do it via Zoom, uh, and or Teams, as it turns out. And so I started thinking about it. I'm thinking, well, you know, technology the way it is, why not expand this to the panhandle area of the state? And then, well, why just limit it to the panhandle? Let's open it up to the entire state of Nebraska. So uh, that's how a lot of you folks got invited, and we're excited that you're joined us. Um, we looked at the registration, and we've got folks here from Scottsbluff, St. Paul, Schuyler, Ord, Loop City, Fremont, South Sioux, Blair, Wayne, Gothenburg, Wood River, Shelton, Deschler, Nebraska City, Sutton, Nebraska. We got folks joining us from Council Bluffs, friends of ours in Council Bluffs, and of course, local folks here in Omaha. Bev Lassick and her group, folks from Palladino. So we're very excited for you to join us. I want to thank Kendra once again for getting us thinking about this and getting the ball rolling. Kendra had a rough morning, and Kendra, don't forget your active shooter training is tomorrow and not today. So she was panicking on that earlier. So that being said, let's get this started with the PowerPoint. I want to thank, uh, before we get started as well, my two staff, Jermaine Gosevac and Talia Hughes, especially Talia, who put this together for us, the technology part of this. One of my staff members called in sick today, so we had to make some adjustments on the fly. But we hope you get some information out of this that you did know before, reinforce some information that you may already know, and hopefully we make some new friends along the way. So let's get started with the PowerPoint, if you will, uh, and get this party started. So about this training, Las Vegas rules apply here. Whatever is said here stays here. Interaction, participation, and questions are encouraged. We're going to be doing some polls that we're going to ask you to be a part of, and you're going to see the results hopefully instantly. So we're gonna be asking you questions throughout the process. Um, we want you to feel free to ask questions throughout the training. Each presenter will answer the questions at the end of their section. Once again, there are no silly questions. Uh, the other thing that I want to enforce is that the information we give you, the examples that we give you, are all cases that we have worked, situations that have come across our desks. So all of these instances, and we'll be interacting the presenters with each other to give examples of cases that we have worked. Um, if your question it doesn't get answered during this presentation, please feel free to contact us afterwards. You will have our contact information. Um, one of the things that we enforce throughout the entire training is that to call us. Uh, we encourage folks to call us if they have questions. Obviously, things pop up are going to pop up after this training. You'll have our direct numbers, our emails, so that down the road, if you come across a situation, please call us. So some technical information about this training, all participants will automatically be muted. So please type any questions or technical issues you have in the chat area. Talia's put in what that chat thing looks like, and I'm the most technically challenged person there is. So when I say that chat thing, that's exactly what I mean, that chat thing. We've included audience polls throughout, and we encourage you to participate, in. The slides will be available to everybody afterwards. Next slide, please. So the training overview, the way this is going to go, I will do the introductions and give some information about the center. Jermaine Gosevac, our Assistant Director, will talk about the Fair Housing Act protections and affirmatively furthering fair housing. Talia Hughes will be talking about our sex-based discrimination, and Jermaine will follow that up with disability protections. And then we will open it up finish it up with best practices and some more Q&A. So that being said, let's go. Let's get this started. Once again, we are the Fair Housing Center of Nebraska and Iowa, which is a program of family housing advisory services. Under the program of family housing advisory services, we have numerous programs that include our tenant services program that provide rental counseling, assist individuals with some, if they're behind on their utility bills or if they're behind delinquent on their rent. Like I said, they provide rental counseling as well. We have our pre-purchase education class that assists individuals who are looking to get into that first-time home, and we have counselors that show them the ins and outs of home buying. We have our foreclosure prevention program that for individuals who own their home, but for whatever reason they're facing foreclosure, we have a program that helps them save their house and try to work out a situation with the banks so they don't become homeless. We have our financial asset education program that assists individuals who to get that money, to get into that first time home, how to save their money, how to take care of any debt that they may have. We have our EIT, Omaha Earned Income Tax Credit Coalition, that does taxes for individuals and showing them what to do and how to get their earned income taxes. We have an Omaha 100 program that assists individuals in getting that loan for first-time home buyers. They work with the consortium of banks to get the best loan available. And then there's us, the Fair Housing Center. We are the only program of family housing that covers all of Nebraska and all of Iowa. All of the other programs cover Omaha and Pot County, Council Bluffs, Iowa. The Fair Housing Center, we have a staff of 6 individuals with over 70 years of fair housing experience. 70 years, that's a lot of years. I've been with the center for 21 years, which means 2 things. I've been doing this a very long time, and I'm really, really old. That's what that means. 2 of our staff are bilingual in Spanish. Next slide, please. So poll number 1 of the things that we're curious about, is if you have ever heard of us or have had any interactions with the center before. I believe on the right side of your screen, please click yes or no, and hopefully we see a result immediately. Just let us know, yes or no, you've heard of the Fair Housing Center before or have had any interactions with us. I'll give everybody about 30 seconds to answer, and hopefully we'll see what that answer is. So it looks like 68% have heard of the Fair Housing Center, 32% have not. So that's good. That's good. Like I said, we've been part of family housing. We've been around since 1994. So it's good to that are those who have heard of us before, and glad to meet those who have not. Next slide, please. What we do at the center, we do a lot of outreach and education presentations. We do a lot of these talks to folks like yourselves, to social service agencies, uh, realtors, landlord associations, general public. We do these all over the state. This year I've been to Norfolk, to Columbus. I did a presentation at the Housing Authority in Grand Island. I've been to Gothenburg, Cambridge, Kearney. So we do these talks, presentations throughout the state of Nebraska. We also investigate allegations of discrimination. Let me back up a little bit. Anything to do with housing, we deal with. When it comes to rentals, sales, bank lending, trailer parks, senior citizen homes, dormitories, anything to do with housing, we deal with. Uh, we are a nonprofit organization. We get funded by HUD to do the work that we do. So we investigate allegations of discrimination. We answer landlord-tenant questions. I take calls from individuals, just like my staff does, uh, regarding I've been given a 7-day notice. Do I have to be out in 7 days? I took 2 calls this morning from a couple individuals who don't have heat, and they haven't paid rent. And I tell them, listen, it is November 15th and it's cold and it's going to get colder, and uh, you have not paid rent, and I understand why you haven't paid rent. I don't blame you for not paying rent, but the law does not allow you to do that. We tell those folks, we counsel them on what their rights are, what that landlord's responsible for to do under Nebraska and Iowa law, and then the information we give them, they do with what they want. They got to do what's best for themselves and their family. But unfortunately, withholding the rent isn't one way to go about getting things fixed. We conduct testing across Nebraska and Iowa. We're not going to talk about testing today. That's going to be for a whole nother seminar that we'll put on at another time. We act as personal representatives, advocate on behalf of our clients. We are not attorneys. There are times where we give folks the information they need, empower them with the information they need to address the issues with their landlord. There are times where they need a little bit more assistance, and that's where my investigators, myself at times, act as advocates on behalf of our clients. We also provide technical assistance to housing providers. We encourage individuals to give us a call. Landlords, folks like yourselves, public housing authorities, to give us a call if they're running into a situation with a tenant, to see if what they can do, what their options are within the guidelines of the law. And I tell folks the same thing I would tell a tenant. I'm not here to tell you how to run your business. The information I do with, you do with what you want. We can help walk you through a scenario if you want to run that by us. I've got a lot of housing authority executive directors that have me on speed dial. Fremont Housing Authority, Rita, Douglas County, Bellevue Housing Authority. They can vouch that they reach out at any point, and I'd be glad, and I'm always willing. We are always willing to help them through a scenario. Next slide, please. So last year, what some of the achievements the center did, we assisted over 1,300 individuals with their housing issues. We investigated 374 allegations of discrimination, filed 46 fair housing and administrative complaints on behalf of our clients, directly assisted 71 disabled individuals in obtaining their accommodation requests, conducted over 130 fair housing tests, trained over 1,400 individuals on fair housing concepts, provided technical assistance to over 300 housing providers, and recovered over $340,000 in benefits for our clients. Next slide, please. So what civil rights laws apply to your projects? The Fair Housing Act, both federal and Nebraska, Title VI of the Civil Rights Act of '64, Section 504 of the Rehabilitation Act, Title 2 and 3 of the American Act of the Title 2 and 3 of the Americans with Disabilities Act of 1990, VAWA, the Violence Against Women's Act, and any state or local anti-discrimination law and ordinance. Next slide, please. So as you may or may not know, it's illegal to discriminate in housing, illegal to treat somebody differently, illegal to place different terms and conditions based on a person's race, color, sex, religion, national origin, disability, or familial status. Those are the 7 federally protected classes, as well as in Nebraska and Iowa. The Nebraska and Iowa law reflect the Federal Fair Housing Act. Those are the 7 federally protected classes each state can add to it, but they can't diminish from it. So it's very important that you folks know what the 7 federally protected classes are, as well as any additional protected classes in your jurisdiction. Next slide, please. So poll number 2, of the 374 cases that the center investigated last year, 79% was on one particular basis. I want you folks to tell me what you think that basis was. Now, those of you who see me present before know what the answer is, and that's fine. Was it race, color, sex, religion, national origin, disability, or familial status? I want you to guess what particular basis was 79% of the cases we investigated last year. I'll give you about 30 seconds to respond. I feel like I should have the Jeopardy theme song playing in the background as this is going on. So we've gotten 24 responses, 52% say disability, 28% say race, and then we got sex, familial status coming in. Last, so all good responses, all good answers. The actual answer is disability. 79% of the cases that we investigated last year were on behalf of people with disabilities. Now that's just not in Nebraska and Iowa, that's clear across the nation. Now I have my own scientific theory of why that is. One of them is because the definition of a disability, which we'll get into that a little bit later. But my other unscientific theory is that I'm Hispanic. I'm never going to be African American, but we all, if you will, have that opportunity to walk out that door, get hit by a car, and become disabled. My point is that being disabled knows no race, knows no gender, knows no religion, knows no age limit. So there's a bigger pool of people to choose from to be who are disabled. So that's my unscientific theory of why that's such a big number. The Fair Housing of Nebraska, Fair Housing in Nebraska and Iowa, the Fair Housing Act reflects, the Federal Fair Housing Act reflects both Nebraska Fair Housing Act and Iowa Civil Rights Act. Both have been certified by the HUD to be substantially equivalent. All jurisdictions must protect the basic 7, have the basic 7 protective classes, but like I said earlier, they're allowed additional protective. For example, in Omaha, age over 40 is protected, creed and marital status. Lincoln, ancestry, and marital status are additional protections. So once again, it's very important for you to know the 7 federally protected classes as well as any additional protected classes in your jurisdiction. Next slide, please. The definition of a covered dwelling under the Fair Housing Act, it reads any building, structure, or portion thereof which is occupied as or designed or intended for occupancy as a residence by one or more families. That's a definition of a covered dwelling under the Fair Housing Act. Next slide, please. So who's responsible? Who's responsible for fair housing? Everyone from top to bottom. The property owner, the landlord, property managers, resident managers, maintenance personnel, office manager, any employee involved in the situation, independent contractors, vendors, public housing agency folks, other tenants, we get a lot of individuals looking for assistance when there's tenant on tenant issues. We'll take an individual who's calling for assistance, saying, I'm having trouble with my neighbor. I've complained to my landlord, and my landlord tells us, work it out between the two of you. I don't want to get involved. You folks work it out. No, no, it's that landlord's responsibility, that owner's responsibility to address the situation. Now, I tell landlords, property managers, that when it comes to tenant on tenant issues, one person saying someone else is doing something, don't take the word of one tenant over another. Just because someone says something's happening doesn't mean something's happening, right? We tell housing providers to witness that violation for themselves. Do not automatically say, and the neighbor says you're smoking pot, uh, because if someone contacts us for assistance and they said they've been issued a 1430 for smoking, and first thing we'll ask them, well, are you? No, I don't smoke. So then we would contact that property owner, that resident manager, and ask them for documentation. What documentation do you have that our client is smoking in their unit? Well, the neighbor complained. That's not documentation. All right. So we tell housing providers that when it comes to tenant on tenant harassment, don't brush it off. Don't take the word of one person over another. Get that documentation, confirm that those violations for yourselves. Okay. Next slide, please. So, were there any questions? I hope I didn't go too fast on that. Any questions, Talia or Jermaine, that I missed that anybody typed in?
No questions have come through, but if anyone has any questions at a later date, they're free to put them in the chat, and we might answer them later, or we can always respond afterwards if anyone wants to contact us for a follow-up.
Okay, all right. That being said, that mysterious voice you heard is my assistant director, Jermaine Gosevac, who's going to talk about affirmatively furthering fair housing protections. KG.
All right. Good afternoon, everyone. Jermaine here. I'm the assistant director of the Fair Housing Center. I started at the center about 10 years ago as a student intern while I was working towards my degree in legal studies. Because I love the work the Fair Housing Center does, so I wanted to continue to support their mission. I ended up staying on and was hired as a fair housing investigator, which I did for about 8 years before becoming the assistant program director just a couple of years ago. So today, we're going to talk about affirmatively furthering fair housing. And during this presentation, you'll probably hear some familiar information, but we'll hopefully also learn a few new things that you'll be able to find useful in your efforts to affirmatively further fair housing and prevent housing discrimination. So we're going to start off by going over some of the provisions of the Fair Housing Act, as well as HUD and its recipients' duties to affirmatively further fair housing. So under the Fair Housing Act, it's illegal to refuse to rent, sell, or otherwise make housing unavailable, or set different terms, conditions, or privileges for the sale or rental of that dwelling based on protected class. It's also unlawful to provide different housing services or facilities based on those classes, or make, print, or publish any notice, statement, or advertisement with respect to the sale or rental of a dwelling that indicates any preference, limitation, or discrimination. So it's also unlawful to provide false information about the availability of a dwelling to someone because of their protected class, or threaten, coerce, intimidate, or interfere with anyone exercising a fair housing right, or assisting another who exercises a fair housing right, such as requesting a reasonable accommodation. It's also unlawful to retaliate against a person who's filed a fair housing complaint or assisted in a fair housing investigation. It's also unlawful to fail to provide reasonable accommodations or modifications for persons with disability. So under the Fair Housing Act, federal departments and agencies have a duty to administer their programs and activities relating to housing in a manner that affirmatively furthers fair housing practices. The purpose of the Affirmatively Furthering Fair Housing mandate is to counteract our nation's history of supporting segregation and discrimination practices, which included segregated public housing projects, redlining and racially restrictive deeds and covenants, and the urban interstate highway system. So we have a short video. In order to repair some of the historic harm caused by discriminatory housing practices of the past, it's important to understand how we got here so that we can learn from our shared history and aim to build more inclusive communities. So I've got another quick poll for y'all to take. The question is, do you believe that there are still property deeds with racially restrictive covenants in the state of Nebraska, ones that prohibit a home from being occupied by people of color? Yes or no? And we'll give it just a few seconds for some responses to come in. Okay, looks like the responses have about stopped. I've got 29 responses. 89% said yes, and 10% believe no, that they don't still exist. The answer is, unfortunately, yes. Racially restrictive covenants can be found in nearly every state in the U.S., including Nebraska. So although the Supreme Court ruled the covenants unenforceable in 1948 due to the Equal Protection Clause under the U.S. Constitution, and although the passage of the 1968 Fair Housing Act outlawed them, the hurtful, offensive language still exists as an ugly reminder of our country's racist past. Amending or removing racially restrictive covenants is a conversation that's unfolding across the country currently, and nearly a dozen states are exploring legislation to make it easier to strike racially restrictive covenants from housing deeds. In fact, senators in Nebraska's unicameral introduced legislation last January called the Unlawful Restrictive Covenants Modification Act. The bill would allow for the removal of unlawful and discriminatory restrictive covenants from deeds upon request through the County Register of Deeds office. Unfortunately, in April, the bill was indefinitely postponed. Okay, so the Affirmatively Furthering Fair Housing mandate applies to all public housing authorities and any recipient of HUD funding. In order to receive federal funds, HUD program participants must certify that they will affirmatively further fair housing and must incorporate affirmatively furthering fair housing planning into their formal written plans. The planning includes completing an assessment of fair housing every 5 years, determining who lacks access to opportunity, promoting integration and the reduction of segregation in their jurisdiction, as well as transforming racially and ethnically concentrated areas of poverty into areas of opportunity. Some ways to affirmatively further fair housing would be to remove barriers to housing and program accessibility through the applicant screening process, through the adoption of formal reasonable accommodation and modification policies, and by providing meaningful access to people with limited English proficiency, applicants and program participants, and also by educating housing providers on the benefits of participating in the Section 8 program. More ways to affirmatively further fair housing would be through education, through outreach and marketing, by reaching diverse communities and people with limited English proficiency. You can do this by working with community agencies that serve underrepresented populations in your area and advertise in a way that will reach a diverse population. You also want to stay up to date on fair housing and equal opportunity guidance from HUD and attend fair housing trainings and civil rights conferences when given the opportunity. So we have another quick poll. The question is, are public housing authorities and other HUD recipients required to provide interpretation services for applicants and program participants who are limited English proficient, so that they speak very little or no English at all? yes, no, or it depends. And so we'll just give you a few seconds to answer. Okay, looks like got about 31 responses so far. And the majority of people believe yes, at about 84%, 6% believe no, and 8 to 9% believe that it depends. So apart from the Federal Fair Housing Act, Title VI of the Civil Rights Act includes additional protections for people with limited English proficiency in federally funded programs. So one type of national origin discrimination is discrimination based on a person's limited English proficiency. And under Title VI, federally assisted recipients are required to take reasonable steps to provide meaningful access to their programs and activities by persons with limited English proficiency. These steps include conducting a 4-step analysis and then developing a language access plan and providing appropriate language assistance. So the actions that a recipient must take to meet the obligations imposed by Title VI are necessarily an individualized determination. There's no hard and fast rule. What might make sense for a large entity may not make sense for a smaller entity. So it's encouraged to do the 4-factor analysis to determine the reasonableness of the language assistance that your program provides. That would take into consideration the number or proportion of limited English proficient persons in your service area, the frequency in which those persons come into contact with your program activities or services, and the importance of this service and information or the activities. And also, it's important to consider the resources that are available to the recipient, both financial and human resources. So some limited English proficiency best practices would include developing a plan to provide meaningful access to your program, having vital rental documents translated in the most common languages, contracting with interpreter services to have them on standby when needed, and hiring bilingual staff if possible. And then at the very least, you should also have a telephone interpreter line in case someone calls or comes in and they don't speak English. And that way you're not just turning them away and you're able to provide assistance so that they can participate in your program. So while you're also examining your policies, you'll want to look for ways to affirmatively further fair housing through the applicant screening process. For example, in 2016, HUD's Office on General Counsel issued guidance concerning how the Fair Housing Act applies to the use of criminal history by housing providers. The guidance addresses how an overly restrictive screening policy may have an unlawful discriminatory effect if it is not applied, even if it is applied equally. So it may have a discriminatory effect even though you're applying it to all of your applicants in the same manner. This is because across the United States, racial and ethnic minorities are arrested, convicted, and incarcerated at rates disproportionate to their share of the general population, due in part to biases in the criminal justice system. Consequently, criminal record-based barriers to housing are likely to have a disparate impact on minority home seekers. While having a criminal record in and of itself is not a protected class under the Fair Housing Act, a criminal history-based restriction on housing opportunity may violate the act if, without justification, their burden falls more often on renters of one race or national origin over another. So in order to ensure your screening policies don't have an unlawful disparate impact on specific protected classes, it's necessary to ensure they serve a substantial, legitimate, and non-discriminatory interest, and must consider the nature, severity, and recency of the criminal conduct. Exclusions because of prior arrest alone are strictly prohibited. A housing provider that imposes a blanket prohibition on any person with any type of criminal record, no matter when the conviction occurred, what the underlying conduct entailed, or what the convicted person has done since then would most likely be considered discriminatory under the Fair Housing Act. A housing provider's policy must show that the policy accurately distinguishes between criminal conduct that indicates a demonstrable risk to resident safety and or property and criminal conduct that does not. A policy or practice that fails to consider the nature, severity, and recency of criminal conduct is unlikely to be proven necessary to serve a substantial, legitimate, and non-discriminatory interest of the provider. So regulations, they can vary widely across subsidy programs. Outside of the following restrictions, housing providers have some discretion in policy application. However, there are some statutory exemptions. Federally assisted housing providers must deny admissions to a household whose members, if any member has been evicted from federally assisted housing for a drug-related criminal activity in the past 3 years, unless their circumstances have changed. For example, the person has completed drug rehab, or the person who had committed the crime in the household is no longer part of that household for whatever reason. And also, you're allowed to exclude any members of the household who are subject to the lifetime registration requirements under the state sex offenders registration program, regardless of any disparate impact that that might have. And that concludes the affirmatively furthering fair housing portion. It didn't look like there were any questions.
Jermaine, can you go back a couple of slides regarding the criminal history? Is that for just PHAs, any federally assisted programs, or does that guideline for all housing providers?
Thanks for asking, Joe. No, this is actually for any housing providers. It would just, any recipient of federal funding wants to make sure that they're being extra cautious, that they're not doing anything to discriminate, but that they're also going a step beyond that by being proactive to affirmatively further fair housing.
Yeah, so when this came out in 2016, it was a big uproar amongst landlords in here in Omaha. A lot of uproar, a lot of kickback on that, but it went for all housing providers, not just those who are public housing authorities who are getting who are federally funded from the government. So it goes for all housing providers.
There was one question earlier asking for specifically like noise complaints where there might be repeat reports of noise complaints at night, but that's something that they can't necessarily witness the landlord. So how would the landlord go about following up or documenting a situation like that?
Yeah, that's a very good question. What I've told folks that if it's that loud, and we've gotten individuals who have asked, my neighbor's making too much noise. I complained to the landlord, but the landlord can't do anything because they haven't witnessed it. But it keeps me up all night. I can't sleep. I'm having problems. And so I explained to them, we explained to them the same thing. Just because you say it's happening, that housing provider needs that documentation. So what I've told them, that if it's as bad as you say it is, if it's keeping you up at night, if you're not able to sleep because of the noise, record it. Record the noise. If it's that bad that it's keeping you up, hit record. Most phones have apps that you can download recording devices, and if you can record it, and then you take it to your housing provider. Say, listen, you don't have to believe me. Here it is. That's one way to get that addressed.
other ways that you can try to document that is talking to other tenants, and that would be exposed to that noise. So trying to see, hey, have you heard these complaints? Have you heard these noises? Have you been home around these times? It's more likely to be a substantiated issue if you have more than one person reporting it. Or you also want to take into account if the person has issues recording it, whether that's disability related or technical stuff, trying to see if they can have like a witness to the noise, or trying to see if one of your maintenance staff, you can also you may want to be careful with telling them to contact the police, but that definitely is an option that tenants have and landlords have, that if it's something where it's extremely disruptive to other tenants, that may be something they want to consider. And obviously if you had a police report, that would be another way of having documentation.
Okay. So without further ado, we're going to move on to the next portion of the presentation, which is on sex-based discrimination. And Talia Hughes, our fair housing investigator, will go over that information. Take it over, Talia.
Talia, you're on mute.
Is that better? My name is Talia Hughes. I'm a fair housing investigator at the Fair Housing Center. I've been here for almost 2 years, I think. Before that, I've worked in disability rights. I've worked in domestic violence advocacy, legal assistance, things like that. So that kind of ties into what I'm here to talk about. For specifically under sex-based discrimination, there are different categories that can be covered under that definition of sex. It's pretty broad. So things like that can be, sexual harassment, that can be domestic violence, that can be LGBTQ issues sometimes. So going into that, domestic violence, there are specific protections under the law for both survivors and victims, including specifically, as mentioned before, the Violence Against Women Act, or VAWA, which applies to most federally assisted providers. It protects and supports victims and survivors of domestic violence, and includes both housing protections, criminal justice system protections, and a lot of other things as well. Under VAWA, the protected tenants or protected people include both the victims of domestic violence, dating violence, sexual assault, or stalking. Can also include elder abuse sometimes as well. The family members living with the survivor, or any affiliated individuals, so family members or other people that are living with the protected tenant at the time. But that doesn't include, obviously, the perpetrator of the violence, any members of the household that are not allowed or reported to be there, or temporary guests, things like that. Some of the federally assisted programs covered by VAWA include public housing, housing choice vouchers, project-based Section 8, USDA, low-income housing tax credit properties. There's also a very long list of other programs, but these are going to be the most likely to occur here, at least. Some of the rights that protected tenants have are, some of them are general and some of them are going to be specific. So generally, you can't take an action against a survivor or protected tenant on the basis of, as a direct result of, or based on an adverse factor that directly relates to their status as a survivor. So if you were to deny an application because that person was a victim of domestic violence, that's protected. That would be a violation of VAWA. If you were to deny assistance to someone because they had a history of police reports because of violence that they'd experienced, that might be, an action taken as a direct result of. Termination of assistance, if they have been a victim, or even if you were to terminate the assistance of someone because there's been damage caused to their property by a perpetrator of violence against them, that might be a situation where VAWA might apply, and you might want to be careful with those actions taken. Also, eviction is a pretty big one that comes into here. When someone is a survivor or a victim and they're enforcing their rights under VAWA, they have the right to self-certify the documentation. So they can say, I have been a victim of domestic violence. I filled out this paperwork explaining what happened in general terms, and that I am a victim. Unless you have conflicting information, so conflicting documentation, both parties involved in a lease submit documentation saying they're the victim, situations like that, then you can request third-party documentation. You can say, do you have some sort of police report? Have you been working with the domestic violence agency, some sort of approved third party under VAWA? You can request documentation there, or you can ask for documentation at other times, but you cannot require it unless there is conflicting information. Also, other rights, they have the right to request an emergency transfer if they're at risk of continued harm. That would be, you would want to look for actual and intimate partner violence and imminent threats. There we go. So a physical danger that's real, that occurs within an immediate time frame and could result in serious harm or death. You might not need to provide an emergency transfer if the tenant says, 5 years ago, I was afraid. But, if the situation is where the perpetrator might come back tomorrow, that's a situation where you may need to take action pretty quickly there. They also have the right to a lease bifurcation to remove the perpetrator from the lease. And you can't take steps to evict them based on the violence experienced by them, unless there is some sort of threat that the survivor themselves is, at risk of creating to the other tenants. The other new provision that is effective as of last month is that tenants, guests, homeowners, landlords, and public housing authorities, things like that, they can't be penalized for contacting law enforcement or emergency assistance. So say a municipality has a rule saying if you have a tenant that calls the police a certain amount of time within a certain amount of, a certain period, then you have to evict them. That would be a violation under VAWA. So these protections are put in place for even housing providers, which I think is pretty cool. They also expanded the definition of homelessness to include families or individuals fleeing violence under VAWA, so fleeing, intimate partner violence. So we have a poll right here. So I want to get some input here. Does the Fair Housing Act protect people facing discrimination because they are gay or transgender? All right. Well, we've got 26 responses and everyone agreed, which is pretty cool. Love the 100% agreement there. And everyone is correct. Yes, the Fair Housing Act does protect people facing discrimination because they are gay or transgender. Additionally, HUD federally assisted programs have other requirements under the Equal Access Rule that they passed in 2012 and 2016, requiring that all HUD-funded programs be available without regard to a person's marital status, sexual orientation, or gender identity. And that can be either their actual gender identity or sexual orientation, how they specifically identify themselves, or their perceived sexual orientation or gender identity. So you can't deny housing to someone based on what you think they identify as. There's also additional equal access requirements for continuum of care programs, CDBG programs, where you have to place and provide equal access in accordance to the person's gender identity. So shelters or gender-specific programs would need to provide access based on how that person identifies rather than how they may have been identified at birth or how the program thinks they would identify. There are also significant limits on what kind of information they can request or documentation they can require and things like that. And then going back a little bit to those protections for gay and transgender people, the Supreme Court held in Bostock v. Clayton County that Title 8's prohibition, which is a employment-based prohibition against sex discrimination, includes sexual orientation and gender identity. Because Title 8 has such a close prohibition and close civil rights laws to the Fair Housing Act, as well as other civil rights acts, then there was a executive order passed that other federal agencies should consider what that implication of the Supreme Court's holding would be. And HUD specifically issued guidance saying that this expanded definition, that sex-based discrimination includes discrimination based on someone's sexual orientation or gender identity, applies to the Fair Housing Act. So with that, they required that all substantially equivalent state and local fair housing laws, including Nebraska, Iowa, those also be enforced to include sex discrimination based on sexual orientation and gender identity. So that, in essence, created or legally enforced the definition that LGBTQ people, including gay people, transgender people, same-sex couples, things like that, have those housing protections the same as anyone else would on the basis of their protected class. So some example,
Prior to 2021, was sexual orientation, gender identity a protected class in Nebraska?
So it was in certain places as a local definition. I believe Lincoln and Omaha both had those specifically explicitly protected. Also, sometimes it could be enforced under the previous definitions before the Supreme Court specifically passed that, but it was kind of unclear and went jurisdiction by jurisdiction prior to the Supreme Court holding. So here we have some examples of specifically discrimination against LGBTQ people. And I realize I've been using the acronym LGBTQ without explaining. Hopefully, that's something that people have heard before, but that just stands for lesbian, gay, bisexual, transgender, and queer people. So things that can be considered discrimination would be to make a decision based on the fact that someone is transgender or expressing a preference for straight couples versus same-sex relationships, steering away from schools or churches, making decisions based on how you feel someone's marriage should be or what you would prefer their marriage to be, if that is based specifically on their sexual orientation or their gender identity, or evicting a tenant for being the victim of some sort of harassment based on this protected class, rather than, trying to protect or enforce community rules and standards preventing that harassment. So finally, we have the end of my section. So did anyone have any questions on any of this? I know I went through some of it a little fast. And obviously, if you have questions after this, feel free to ask those, reach out to us at any time. This is my pet interest, so I'm very familiar with these kind of requirements. Okay. Well, I'm not seeing any questions in the chat right now, so I will pass it back to Jermaine to talk to us about disability.
All right, thank you so much, Talia. So as was mentioned earlier, allegations of housing discrimination based on disability make up a vast majority of complaints we see at the Fair Housing Center. And this is also a national trend, with upwards of 60% of all complaints filed nationwide being based on disability. We believe this is for a number of reasons. For example, the prevalence of people living with disabilities is high, given the broad definition of disability under the Fair Housing Act. And there's also an increase in community resources and advocacy for people living with disabilities. And housing providers often lack knowledge on their duty to provide exceptions to the rules, policies, and practices in order to accommodate people with disabilities. So just a few statistics for you on the prevalence of disability. Disability is one protected class that anyone can involuntarily join at any time, as Joe had illustrated earlier. And in fact, in the United States, about 61 million people identify as having a disability. And in Nebraska, that's over 300,000, or 20% of our population. Many of these disabilities are not visible. Invisible disabilities are, for example, mental health impairments, pain-related conditions, or respiratory ailments such as asthma, COPD. So, disability in the Fair Housing Act. The Fair Housing Act didn't originally include disability as one of its protected classes, but it was amended in 1988 to include disability as a protected class. And it also included categories for additional protections under design and construction of new dwellings, as well as reasonable modifications to existing dwellings and reasonable accommodations to rules, policies, and procedures. In addition to protecting people with disabilities, the Fair Housing Act also protects the people living with them or associated with them. So under disability protections, you don't just have the Fair Housing Act that applies to you if you receive federally financial assistance. You also have Section 504 of the Rehabilitation Act, which was passed to protect people with disabilities from being denied participation in and the benefits of programs that receive federal financial assistance. And under Section 504, reasonable modifications are the same as reasonable accommodations. And we'll get into that a little bit further later on. It does not apply to all federally assisted housing providers. There is an exception for providers that receive low income housing tax credit because it's not a direct subsidy. And it also does not include private landlords who participate in the tenant-based Section 8 voucher program. So the definition of disability is the same under the Fair Housing Act, Section 504, and the ADA. And it is defined as a physical or mental impairment that substantially limits one or more major life activities, such as seeing, hearing, walking, breathing, performing manual tasks, self-care, etc. The list is not exhaustive. So, determining who meets these requirements. How can you tell? Well, it may be readily apparent or otherwise known to you already that the person has a disability. In situations where the disability isn't obvious, such information may be obtained from a credible third party, such as a doctor, a physician's assistant, other medical professionals, therapists, counselors, a peer support group, a non-medical service agency, or other reliable third party who is in a position to know about the individual's disability and how it affects their daily life activities. Also, records from government agencies or insurance companies may provide such verification of the presence of a disability. In most cases, an individual's medical records or detailed information about the nature of the person's disability is not necessary to determine the status of disability. So we've got a quick poll question for y'all. As noted earlier, when the Fair Housing Act was amended in 1988, it included provisions to ensure that the construction of new dwellings would be accessible to people with disabilities. So how many design and construction provisions do you believe are required by the Fair Housing Act? And for options, we have 10, 3, 7, or 5. And we'll give you just a few minutes to go ahead and vote. Got about 27 responses, 28 really good answers. 75% of you hit the nail on the head. The number is 7. There are 7 minimum accessibility features that must be included in all multifamily dwellings designed and constructed for occupancy after 1991. They include accessible building entrance on an accessible route, accessible common and public use areas, such as a leasing office or a pool or other amenities that are provided, usable doors, accessible route into and through a unit, accessible light switches and environmental controls, such as a thermostat, reinforced bathroom walls for the installation of grab bars at a later time, and usable kitchens and bathrooms. So not all property was built after 1991, and people that live in older constructed properties, they may need to request modifications of that structure in order to use and enjoy the dwelling. So the Fair Housing Act states that a housing provider has to provide reasonable accommodations, which is a structural change made to the existing premises that allows a disabled person to have full use and enjoyment of their dwelling. These modifications may be made to the interior or the exterior of the dwelling, as well as public and common use areas. Housing providers must allow reasonable modifications unless they are unreasonable or bear no connection to a disability whatsoever.
Jermaine, will you share the case that you had with it was out of town with the Public Housing Authority where they had change up some cabinets or countertops or something like that?
Yeah, so we've done a lot of reasonable accommodation modification requests to private and public housing providers. And so if it's a private housing provider, they have to allow a modification to be made, but they don't have to pay for it. However, if you're a public housing authority, you would have to pay for any modifications that are necessary that are requested by the tenant. So not that long ago, we had received a request from a gentleman for assistance, and he needed a lot of modifications to his new dwelling to be able to use it and to enjoy it. And the housing authority that we had contacted, they were great to work with. They jumped right on it. They lowered cabinets, they lowered cabinet tops, they widened doorways, put in grab bars, widened doorways. They even put buffers on the bottom of lower half of the walls so that his wheelchair wouldn't scratch the walls and create damage. So, I mean, I thought that was a really great example of public housing authority going above and beyond to make sure that, you know, their participants are able to use their dwelling, but also to enjoy it. So, like I was mentioning, housing providers who receive direct financial assistance, because of 504, they have to pay for the modifications, unless it would create a significant undue burden. And in that case, you would need to propose alternative accommodations that would also meet their needs. And then if there's no federal financial assistance, the tenant is required to pay for the modifications themselves. So as I was mentioning, some examples of modifications would be installing grab bars in the bathroom. It's very common. Installing a door ramp to go in and out of a building, lowering the entry threshold of a unit so that somebody in a wheelchair can easily roll in and out, or removing the below counter cabinets so that somebody in a wheelchair could roll up like to a sink and do dishes, or adding visual or tactical fire alarm systems for people with visual and hearing impairment, or replacing a tub with a roll-in shower or no entry shower. So I've got another quick poll for you about parking spaces. Is providing an accessible or assigned parking space considered a reasonable modification or a reasonable accommodation? And the options are modification, accommodation, or I'm not sure. So go ahead and give a few seconds for people to answer. All right, we've got about 29 responses, and you guys know your stuff. It is considered an accommodation. So even though there can be some structural issues, courts have treated requests for a parking space as a request for a reasonable accommodation, and has placed the responsibility on providing that parking space on the housing provider. Even if the provision of accessible or assigned parking space results in some cost to the provider, for example, it may include creating signage, repainting markings on the concrete, redistributing spaces, or creating curb cuts. Those would all be the responsibility of the housing provider. And that is actually not just for recipients of federal funding, but any housing provider is required to do the same. Okay, and that leads us into reasonable accommodations. So while the general fair housing guidelines are to treat all applicants and residents consistently, the law also addresses the right of individuals to equal access to housing. And in order to have that equal access, people with disabilities have the right to request reasonable accommodations. So under the Fair Housing Act, providers must make reasonable accommodations in their rules, policies, practices, or services when such accommodation is necessary to afford a person with a disability equal access to services, programs, or activities. Accommodations can be requested at any time during the application process, after, during their tenancy, even if they're undergoing eviction processes. You still have to allow accommodations at any point in time. And the requests do not have to be in writing, although that's preferred. They can also be verbal requests. And they don't have to use any specific terminology, for example, reasonable accommodation. A lot of tenants won't know that terminology, but yet they'll be coming to you about an issue that they're having that's related to their disability and asking for some type of exception or adjustment. And it's on the housing provider to recognize that that person is in fact requesting a reasonable accommodation. So in response to a request for an accommodation, you'll want to consider the following questions. Number one, does the person have a disability? And number two, is the accommodation requested necessary to alleviate the symptoms of that disability or to allow them to use the housing and enjoy it? Once a request for an accommodation is made, a housing provider has a duty to respond in a timely manner. If the disability is not readily apparent or otherwise known to the housing provider, you may request additional information to confirm the existence of a disability and/or the need for the requested accommodation. This process is called the interactive process. After a tenant or applicant requests a reasonable accommodation, the housing provider has an obligation to engage in such an interactive process with the tenant or applicant. A delay in responding to a reasonable accommodation request may be considered a denial, and that could lead to the filing of a fair housing complaint. If you do not participate in the interactive process or you create an undue delay in responding, you may be violating the Fair Housing Act and/or Section 504. So what is considered reasonable and what's not? Reasonable does not impose a financial and administrative hardship on the housing provider. Reasonable does not create a direct threat to health and safety or to property, and it does not disrupt the peaceful enjoyment of other tenants, and does not impose fundamental alterations in the nature of the housing provider's program. So it may be unreasonable to grant a request if there's no connection to a disability, meaning that it's not necessary, or that it's not reasonable. So it wouldn't be considered reasonable if it posed an undue financial and administrative burden on the housing provider, or by allowing that accommodation that is then creating a direct threat to the health and safety of others. So the accommodation, if you believe that it does pose such a threat to health and safety or property, you'll want to actually do an individualized assessment to determine that threat, and don't make any assumptions just based on perception. For example, someone might request to be allowed to have their service animal, but their service animal is a pit bull, and pit bulls look mean. Therefore, you believe that it might create a direct threat. You have to actually have direct knowledge that this animal is a direct threat, not just a perception of it. And also, it cannot create a fundamental alteration. It has to be within the scope of the housing provider's program or the services that they provide already. So for example, if someone has physical disability and they are no longer able to take their trash out or go to the grocery store, pick up their, their medications, they can't contact the landlord and say, I need you to run to the pharmacy for me, because that's not a service that you already offer as part of your program. You could deny that type of request.
We also, we had a case a couple years ago where an individual called in wanting assistance. He was in a wheelchair and he had a service animal, and he was able to take his dog out for the dog to do his business. But he said probably about 97% of the time, he told me I'm able to pick up the poop after the dog. It goes. He goes, but there's 3% of the time where I'm not able to get it because the dog goes out too far. I'm in a wheelchair. It's in a grassy area. He goes, and if we don't pick it up immediately, we're issued a 1430. He goes, and it's going to happen. He goes, so he asks us to assist him with having the housing provider pick up the poop on the times that tenant wasn't able to get the poop himself. And I told the guy, no, that's not the housing provider's job to pick up poop after a dog. But that being said, let's figure something out. So I asked the guy, I said, are you, the 3% of the time, that's very rare. So at those times when you're unable to pick up the poop after the dog, do you have a friend, a family member, a neighbor that you can tell or ask to get that poop for you the 3% time that you're unable to get it? He said, yeah. So we approached the housing provider on that client's behalf and say, listen, when the dog goes and he's unable, the tenant our client is unable to pick up the poop, he can come in and notify you, say, listen, my dog went. Can I'm giving you notice that my dog went and I'm getting somebody to come down and get it. We ask that housing provider to give at least 24 hours for that client to call somebody, come in and pick up the poop, so as to avoid that 1430. So although it was outside of the scope of what that housing provider does, they had to come in with the interactive process of figuring out a way to assist with that reasonable accommodation. So that's a good
Yeah,
example.
thanks, Joe. That made me think also of another example, as far as like engaging in the interactive process. Just because it might not be a service that you provide, you don't want to just shut down the person that's making the request. You want to try to work with them to find alternative ways that might also meet their needs. I'll take, for example, the trash situation that I had mentioned earlier. It may not be reasonable to have the maintenance man go to the tenant's apartment every day and collect their trash and take it to the dumpster because they're unable to physically put it in the dumpster themselves. But an alternative may be to put a smaller bin next to a large dumpster that the tenant could easily put their garbage in. And then when the maintenance man is on site or is around, they could empty the smaller bin into the larger one. So it's just working with the person to find an accommodation that would work for them is always the best policy if you're unable to provide it off the bat. So some common examples of reasonable accommodation are creating reserved handicap parking spaces, transferring a tenant to a ground floor unit that might be on a second or third floor, and maybe there's been a progression in their disability, or they were recently diagnosed with a disability that prevents them from being able to go up and down the stairs. They may need to be transferred to a ground level unit, or allowing a later due date for monthly rent payments for people that receive Social Security for disability, so that the due date of the rent coincides with the due date, with the date that they receive their benefits. Also extensions on due dates, move out dates, or on evictions. We see that sometimes people that have issues with housekeeping, and they might have gotten a notice that they're under threat of eviction because they're not meeting certain, quality control standards for housekeeping, which is perfectly fine. They do have to also comply with rules, but they might need additional time to cure such violations. Maybe they need to get a chore provider assistance, or they need to seek additional services because they're injured or hurt, or they had surgery and were unable to take care of their home for a short amount of time. Just working with somebody that's challenged in this situation because of an impairment that they have. Also granting an early lease termination without penalty. If someone is no longer able to use their housing because of their disability and they need to relocate. We have seen that a lot with people that are elderly and who are moving into assisted living or into nursing homes because of needing more care. The landlord should then terminate the lease without penalty and not charge them like a buyout fee that they might normally otherwise charge. And also waiving a no pets policy to allow for assistance animals, whether that be a service animal or an emotional support animal. In addition to that, housing providers are not allowed to charge a pet fee or a pet deposit that they might normally charge if they do allow for pets on their property, because those assistance animals aren't technically considered pets under the Fair Housing Act. They're more akin to an assistive device like a wheelchair. So you wouldn't be able to charge somebody with a disability a higher security deposit because they have a wheelchair and you're concerned that it might damage the walls or the doors or what have you. It's the same thing with pets. If you assume that a pet might create additional damage to a property, if it's an assistance animal, you cannot charge them the typical pet deposit or pet rent. I will add on to that though, if a tenant's assistance animal does create any damage to a property, they are fully responsible for that damage and for paying for that damage once they do move out.
Talia, can you give, before we get into the assistance animals, Talia, you just did an intake a couple of weeks ago on a elderly woman who I think the complex is changing their policy to pay via the portal. And this is an elderly woman who has, I believe, COPD. You did the intake for me a couple of weeks ago. Can you explain what we're doing for that client?
Yeah, so she has so I mean, I don't really want to talk about this specific client, but don't give out confidential info. But in general, cases like this, if the person has visual difficulties or physical difficulties, that means that they, can't use the website to pay online for their rent, or they are not able to use the internet or things like that, we can do a reasonable accommodation to request that they be allowed to pay their rent in another way. So, if they were able to bring checks to the office before, asking that they be allowed to continue doing that, or pay, have someone bring it to the office, or pay via, a money order in the mail, or working with the housing provider to come up with a reasonable accommodation that allows them to continue to pay their rent on time as they always have, but not have to use that online portal.
Yeah, it's very important to know that the request for the reasonable accommodation there's got to be a nexus. There's got to be a connection between the request and the person's disability. Um, so just keep that in mind when someone approaches you for a reasonable accommodation.
Okay, so going back to assistance animals, we did just want to make the distinction between service animals and support animals. So um, a service animal is actually defined under the Americans with Disabilities Act as any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability. Also, on rare occasions, that does include a miniature horse as a service animal. So it's either any dog or a miniature horse that is individually trained to provide such a service. Whereas the definition of a support animal is much more broad under the Fair Housing Act. And it can be any species of animal, trained or not, that performs tasks, does work, and or just provides emotional or therapeutic support for individuals with disabilities. So I've got a little chart here because I know a lot of people are visual learners like myself that breaks down service animals versus emotional support animals and defines them. So like a service animal trained to do work to perform specific tasks, defined under the ADA and also under the Fair Housing Act, only a dog or miniature horse, a housing provider, or the people in the public cannot request any additional written information or documentation from somebody that has a service animal. And they're allowed to have service animals in housing as well as in public accommodation. So this public accommodation piece is one of the big things that differentiate the two. So emotional support animals are not allowed in public places. That's only service animals, but they are allowed in housing. You have to allow emotional support animals in housing. You may request additional documentation to confirm that the person has a disability related need for that animal if it's not already obvious or readily apparent to you. And it can be any animal. It doesn't just have to be a dog or a miniature horse. And only the Fair Housing Act is what you would need to look at as far as regulations goes for emotional support animals.
I just wanted to add a little bit to that any animal part for the assistance animals. I've had several cases where there's been, additional animals or specifically like exotic animals that the landlord's not used to granting, and there are specific rules that HUD requires to take into consideration. You don't just have to say, yes, you can have this ostrich in this house. Part of that reasonableness is this unit set up for being able to take care of this animal? If it's a chicken, then maybe they need to have an outdoor pen that's secured and has space for them to eat. Whereas, a dog, there's a lot less things to consider. So there is still parts of that reasonableness that go into that.
Exactly. Thank you, Talia, for mentioning that. And in 2020, HUD put out new guidance to clarify some of the issues that they were seeing between service animals and emotional support animals. So that's something that you might want to look at if you're wanting to learn a little bit more about it. And it does dive a little bit deeper into some of the exceptions or exclusions because of exotic animals and animals that aren't your normal domesticated pets, if you will.
And we've had cases where we've represented clients who had chickens who were emotional support animals. And I still find this fascinating. Did you folks know that there's no such thing as one chicken? There's always chickens come in pairs because one chicken can't survive on its own. I just found that out recently. I'm a city boy, so obviously it was news to me. But yeah, there's no such thing as one chicken. There's multiple chickens. And then Jermaine, can you tell us, are there any breed restrictions, weight restrictions, limit on the, because we get a lot of calls, limit on how many
Yeah.
ESAs a person can have?
Right. So there can be no prohibition on specific breeds or weight restrictions when it comes to assistance animals for your typical domestic animals that somebody would have as an emotional support animal or a service animal. Having more than one emotional support animal can be kind of tricky. Obviously, you would want to get some type of verification from their medical provider that clarifies why the person needs more than one assistance animal. Sometimes it can be a household, and maybe one assistance animal is for a parent, and then another assistance animal is for maybe a child in the home. So in that situation, you could request notes from both of those disabled persons providers to confirm that they both need their specific animal. If the person themselves needs multiple, then the doctor's note would need to clarify why they need each animal.
Okay. We have a couple
Couple
of
of
questions.
Mhm.
Melinda's asking, is a reasonable modification a temporary ramp for a child that has surgery and is using a scooter?
Yes, that would be an example of a reasonable modification. And if it is a public housing authority or a property that receives direct financial assistance, they would be responsible for installing that ramp.
Patty, good question, because I was going to bring this up. What if your city has animal ordinances that prohibit owning a specific breed of dog, like a pit bull or Doberman? Gee, share
Yeah.
the town you took on.
Well, so
Well, not
was
the
it
town.
was it was either this year or the end of last year, we started getting a whole string of calls from several individuals from one tiny town in Nebraska, and they had one thing in common. They all received a letter from the city stating that their animal, their dog, had been deemed a dangerous animal, that it was that they have an ordinance of dangerous dog ordinance, and it listed a whole array of dogs. Practically any large dog you could think of besides a lab or a golden retriever was on the list. And multiple of the people that had called us had German shepherds. One had like a pit bull type dog. And so they came to us because they said these dogs are, our service animals. We use these dogs for emotional support. We have certifications for them. We can get doctor's letters for them. So I had reached out to the city attorney for this town and spoke to them about their ordinance and specifically how it didn't spell out that there was an exception for people that needed an accommodation, an exception to their policy because of a disability. It did note something for service animals, but it did not note anything for your emotional support animals. And so I had told them about the law and provided some information to them. And we got the doctor's notes and we sent them over, and they ended up amending their ordinance to include assistance animals of any type, regardless of whether they were on the prohibited breed list. And so we made that accommodation directly to the city. And so to answer your question, if the city that you live in prohibits a specific type of dog, and someone in that city needs that animal because of their disability, we would then approach the city to request a reasonable accommodation for that animal. So we would never want a landlord to put themselves in jeopardy or any kind of liability by denying that request, because they have to allow it under the Federal Fair Housing Act, and the federal law supersedes any state law or local jurisdictional law when it comes to breed ordinances. So if you do find that happens, please feel free to contact us and we will look into it.
The other consideration. Oh,
I was
just going to add the other The other consideration with breed restrictions is sometimes housing providers will say, my insurance won't cover me, or they'll drop me if I allow this type of animal. And HUD has specifically issued guidance stating that if an insurance company does not grant accommodations for specifically, assistance animals, then they may be in violation of the Fair Housing Act themselves, because as part of the housing industry, and they have certain obligations under the Fair Housing Act as well. So, cities and insurance companies and housing providers all have certain obligations under the Fair Housing Act, and some part of that is providing accommodations. So if you have any issues with your insurance companies as well, contact us.
The other thing is we get a lot of requests from housing providers, landlords, public housing authorities who have been given a letter from a doctor and they don't believe it's legit. They ask us to look it over, and I encourage that. If you have a letter from a doctor, from a tenant who wants an ESA, and you're not sure, contact us. We'll be glad to look it over. We also provide, Talia put together a letter, what do you call it? A sample letter that we provide to housing providers that they can give to their tenants, so that tenant can give to the doctor of a proper way to write out draft an emotional support, or for reasonable accommodation. Doesn't have to be for an ESA. So once again, if you have any questions or want us to look over something, by all means, give us a call. A couple of questions. Let's go back to Melinda. Asked, does the temporary ramp need to be built to ADA specs, or can we use what will work since it's temporary?
I would say it's best to use some type of safe harbor guidelines as far as design and construction of a ramp, because if it's too steep, that could create some safety hazards, and might injure somebody, and then that could be potentially liability for your agency that you wouldn't be wanting to incur.
And there are different safe harbors that can be used. It doesn't have to be ADA. So there's like a Fair Housing Act design manual, and there are other safe harbors that can be used that might be a little bit more flexible for a temporary accommodation.
And we have some of those ADA manuals that we can provide upon request. So please feel free to reach out. Kendra's asking regarding an ESA, does a verification have to be from a doctor?
It does not have to be from a doctor. It could be from a physician's assistant. It might be from a counselor or a therapist. You wanted to make sure that it's from a third party that has knowledge of the disability and how it affects the person's daily life activity. HUD, in their reasonable accommodation guidance, they even list clergy as an example of somebody who would be trustworthy to provide that third party verification. And like I had mentioned earlier, if the disability is readily apparent, obvious, or otherwise known to you, then you shouldn't be requesting any verification from the doctor.
The other thing that we're seeing too is people are selling certifications and registrations for your emotional support animal. Pay us $45, fill out this questionnaire, we'll issue you this registration, this certification. Yeah. Those do not have to be accepted. This letter, this verification has to come with someone with firsthand knowledge, has to have spoken with them, has to have some type of diagnosis that this person does indeed need this ESA. So anything that someone has to pay for, you do not have to accept.
And the housing provider can, if they have questions about the documentation, they can ask for the medical provider to contact them, or to be able to contact the medical provider directly. So if it's a letter from the internet, you can ask to speak with the provider, because there's a difference between someone that someone sees over, like a telehealth provider versus one that they pay for. So you can ask questions regarding those if you have concerns.
Thank you, Talia.
And I believe Nebraska was trying to pass something this past session about having housing providers be in state. I don't think that passed.
It did not.
Yeah. So no, they don't have to be in state. People transfer from state to state with technology the way it is. A provider can meet with them via Zoom, that type of deal. So it doesn't have to be in state. Looks like we have another question from Bev. Regarding a live-in aid, do we have to accommodate additional family members of the live-in aid if, as a housing authority, they are not overhoused? That's a full question.
Wow, that is an interesting one. I have not heard that before. The general rule for live-in aids is that the person is only living there because they're needed for assistance from the person that is the tenant. And so if they were to bring family members with them, those family members wouldn't necessarily qualify as the live-in aid because they're not there in order to provide that assistance. But it could be argued that they are needed to be there because the person that's there providing that assistance wouldn't be able to be there absent the family members, especially if the family member is like a minor child that tags along with the parent while they're doing this care. That is a very a difficult question. I have not thought about that. Talia, what do you have?
In situations like that, that would be a very case-by-case basis where we would have to look at the entire situation and take, all those different factors into account.
That's a good point, Talia. And with any case, it's not, there's just no one general answer. Everything is fact specific. There's a lot of scenarios, a lot of variables that go into an answer. So when someone contacts us, we do an intake, we ask questions. And the other thing I wanted to touch base on real quick is that just because someone contacts us, want to complain about their landlord or complain about their public housing authority, doesn't mean that it's automatically a discrimination case or whatever. What we try to do is we get the information, and here again, I mentioned it earlier, just because someone, as you folks know, you don't always get the entire story, or there's always, the truth usually lies somewhere in the middle. So if we contact you, if you get a call from Jermaine or from Talia, or in some cases, those of you who remember Leslie Seymour, the hair on the back of your neck might be standing up. Doesn't mean you're in trouble. It means that someone's contacted us. We want to get your side of the story. So just because the Fair Housing Center is contacting you doesn't mean you're in trouble. It just means that we got contacted. We're trying to get documentation, trying to resolve the issue so both parties can remain doing business with each other. You have a place to rent, they need a place, continue to cohabitate together. So just because, like I said, you're getting contacted by one of us doesn't mean you're automatically in trouble. We're here to help rectify the situation, if you will.
All right, so that leads us into our last portion, and Joe, I'll let you take it over.
Okay, thank you. We're going to give some best practices here, just some helpful hints for you folks. Let's go to the first slide. So know your state and local laws. State and local laws often provide broader coverages and prohibit discrimination based on additional classes not covered by federal law. Like I said earlier, know the 7 federally protected classes: race, color, sex, religion, national origin, disability, familial status. Those are 7 federally straight across the board. Each state can add to it, but they can't diminish. There are some jurisdictions with additional protections. What we like to say around here, ignorance of the law is not a defense. So if you know the law, If you don't know the law, contact us, and we'll be glad to help you through this situation. Know your responsibilities. Tenants, leasing agents, and case handlers all have rights and responsibilities under the law. Um, be consistent to the best of your ability. Be consistent in how you say, offer, show, hand out, ask, interact with clients to the best of your ability. Be consistent in what you say, offer, what you tell folks. Be careful what you say. Avoid using phrases or expressing opinions and imply a bias or preference. Leave your opinions out of it. Your opinions don't matter. We all have our likes. We all have our dislikes. Um, when you punch the clock and you're on that company time, keep it business. Keep your opinions out of it because your opinions may differ from others, uh, and your opinions don't matter, quite frankly. Just keep it business. Have written policies. Have your policies and procedures written down. Don't fly by the seat of your pants. Don't make them up as you go along. Have those written policies. That's a good point. Uh, Going back to the ESAs, people say landlords, well, fair housing. I let you have your dog. I have a no pet policy. Fair housing is all about treating people equally. If I let you have your dog, then everyone's going to want their dog. What do I tell the other tenants? When I get those type of calls from landlords, I tell them, listen, number one, you don't owe the other tenants anything. But it's a good practice to say, we follow fair housing guidelines. Put that in your lease. We follow fair housing guidelines and point them. That's all that needs to be said. Put that in your lease that we follow fair housing guidelines. Close, case shut, enough said. Um, that's just a good, that's also a good, to have, that's good example of have it in your written policies. Keep it professional. Any housing decisions should be based on business, not on a person's protected class. There's only one color that should matter, and that color is green. Um, keep it professional. There you can deny. Document. Document any denials. Person doesn't make enough money. Bad references. Don't have a bad credit score. Um, Keep it professional, make your business decisions based on business. All right. And then don't guess. If you have questions and you want to know if you're operating within the guidelines of the law, give us a call. We're not attorneys. We will never tell you what to do. We will tell you what the law is and help walk you through the scenario. Like I said, I've a lot of housing authorities contact us with questions. Always happy to answer, help you through a situation. So please do not hesitate to contact us with your questions. Next slide, please. And any other questions? Let's see here. Does the verification have to come from a doctor regarding living aids? Will the slides and also links that are provided on the chat be available to us to download? Talia, is that correct? They will be?
Yes, I am getting the link to put it in the chat right now. There we go. So there are the slides, and then we can also, we'll send an email out to the people who have attended with a link to the slides and the links that we provided in the chat as well. So you'll have access to all of that.
All right, great. And I believe, is there our contact information on the slides? Oh, wait, no, let's go back. Let's go back one. I need to know, I want to know, did you learn anything new today? Well, our final poll, yes, I did. No, I didn't, or a few things. No, not really. And we shouldn't even put no, because if you're going to put no, I want to ask you to lie. Put at least I learned a few things, all right? So yeah, hopefully you folks learned something. Hopefully you enjoyed it. We try to keep it interactive. We try to give, we always do real life case scenarios of what we did. Hope this was informational, that you learned that no one said no, and I'm looking, and thank you for your time. I don't see no, so that's good. For being here. Um, I could not get the slides. Lori, uh, I think our email is on the next slide, right? Yeah, there's our contact information. Right, give us an email or contact us with our phone numbers. We'll be glad to provide you those slides so that you have them. Here again, I cannot reinforce enough to if you don't have questions, but down the road you have questions, by all means, give us a call. We're here to help. We're here to work with each other. I want to thank once again Jermaine and Talia for putting this together. When Kendra asked me if I could do this, I can't because like I said, I'm the most technically challenged person that you're ever going to meet. But I have staff um, that a wonderful staff that are well, they're also a lot younger than me too. That are know these things. Um, we don't know all of the answers by no means, but we will find out the answers. Um, I don't know. Like I said, I've been doing this 20 some years and I'm still learning. I pride myself on uh, surrounding myself with people who have the skills that assist us doing the work we do. I can't thank you folks enough for being here, for asking such great questions. Um, yes, I learned a lot. Can you put the contact info card one more time, please? There's the information. Can
The
you email
link
the
to the
slides?
slides is having difficulties, so I will email it out to everyone that registered and participated, as well as everyone who put their email in the chats. So I will get that figured out and send you out the slides, so you'll have that.
Right.
I'll figure it out.
Thank you.
Very good. Thank you. Jermaine, Talia, you have any final thoughts or words of wisdom?
No, just want to thank
Thank you
everyone
guys
for
for
being
being
here
here.
today. Yeah.
Yeah, you folks have been great. We appreciate it. Um, so if there's no other questions, we'll let you sign off and go home. And thank you again for being here. Appreciate it.
Take care, everyone.